And I call the member for Charlton.
Thank you, Deputy Speaker. I rise to oppose the legislation entitled Building and Construction Industry Improving Productivity Bill 2013, and I oppose it because not a single extra building worker will get home safely because of this bill. Not a single extra building worker will avoid losing their entitlements from collapsing companies because of this bill. What will happen is the 5,000 building workers in my seat of Charlton and nearly 1 million Australia-wide will lose their fundamental rights. Sadly, this bill is not aimed at productivity, it's not aimed at strengthening the economy, it's aimed at destroying the basic rights of Australian workers, and it's built on a tower of sand. Every single economic fact that I will present in my speech demonstrates that the industry is in good shape, productivity is strong, industrial disputation is down, safety is increasing. We do not need this bill. This bill is purely aimed at attacking workers and destroying trade unions. It's typical of the Orwellian approach of the new government to entitle it the Building and Construction Industry Improving Productivity Bill. Let's look at the industry first. The construction industry is a vital sector of the economy. It's grown strongly over recent years, averaging growth of around 2.9%, outgrowing other sectors of the economy. It contributes over $100 billion to annual GDP, employs around 900,000 people, constituting 7.5% of the total workforce. In my electorate of Charlton, the percentage is even higher. 8.3% of workers in Charlton are employed in the construction industry. This is almost 5,000 workers in my electorate that will be adversely affected by this legislation, Deputy Speaker. While the government alleges that the introduction of this bill will improve productivity, there is no credible evidence to substantiate this claim. It's based on flawed and discredited analysis. It is yet again dodgy research driving their approach. They've attempted to justify the return of the ABCC by referring to a recent report by a consulting firm called Independent Economics, a firm formerly known as Ecomtech. What they won't tell you is this firm has a long history of churning out report after report which attacks workers and their unions while supposedly demonstrating a path to improve productivity. What the member for Sturt failed to disclose when he introduced this bill was that this consulting firm once had the rare distinction of producing modelling so inaccurate that the former federal court judge Murray Wilcox slammed the work as deeply flawed and recommended that it ought to be totally disregarded. This is the factual base that the government rests their justification for this bill on, Deputy Speaker. But attacking workers does nothing to improve productivity. Productivity improves when workers are guaranteed safe and fair working conditions. This bill, which will reintroduce the ABCC, was never about productivity, Deputy Speaker, nor was it about taming an industry out of control. This is a robust industry. There are bad actors on both sides of the industrial landscape in this industry, that is without doubt, but there is no evidence to suggest that disputation in this industry has materially increased in the period since the ABCC was abolished, or that the disputation in the construction industry is at historically high levels. The fact is that under Labor's Fair Work model, industrial disputation remains comparatively low. So why is it then necessary to make these changes, Deputy Speaker? The truth is it's not necessary, it's ideologically driven, just like Work Choices was. It's only ever about attacking unions and workers' rights. Let's look at the origins of this bill. In the second reading speech by the Minister for Workplace Relations, who introduced the original ABCC in 2005, he directly referred to unions no fewer than 9 times and stated they were specifically targeted to address union activity. The previous speaker, one of the West Australian members, was very obvious in saying that this bill is designed to attack the CFMEU in particular. To be honest, at least they're not hiding their true colours in their speeches. Mr Deputy Speaker, then as is now, this bill was an attack on unions. It's a deliberate and orchestrated attempt to destroy unions that represent the construction industry. But they haven't stopped there. They've extended the definition of building work to include offshore construction and transport and supply of goods to building sites. These means that these new measures will apply to workers in the maritime industry and the transport industry, and it could extend to the maritime manufacturing industry. This is another case of this government attacking workers' rights, not just in the construction industry, but in every other industry they can get their hands on. This is truly a back-to-the-future time. The construction workers that I've met in my electorate are hard-working Australians just like every other worker. They have families and mortgages, and they expect, as they should, a fair day's pay for a fair day's work. Most importantly, they expect to return home from work safe. Every worker is entitled to a safe workplace free of injury. I've met families who have been affected by workplace safety incidents, by workplace deaths, and it's a tragedy. Even one worker dying at a workplace is one too many, and this bill sadly does not improve safety, it undermines safety. As I said before, Mr Deputy Speaker, every worker is entitled to a safe workplace. Unfortunately, this wasn't happening under the industry when the ABCC operated. From the time the ABCC was introduced, the rate of workplace fatalities increased every year until Labor was elected. Their model organisation for industrial harmony and improving the construction industry occurred at the same time as fatalities in that industry increased year on year, Deputy Speaker. I'm proud to say that under Labor's Fair Work model, fatalities in the building and construction industry declined. According to the ABS last year, the construction industry saw the lowest fatality rate in history of 1.93 deaths per 100,000 workers. Very much lower than under the former government, the coalition government, where it peaked at 2.95 deaths per 100,000 workers. Fatalities in the construction industry were fully a third higher under the last coalition government than what they were last year. Also under Labor, workplace injuries declined. And let's talk about productivity for a second, because they've tried to title this bill about improving productivity. Well, the facts are this. Labor productivity in the construction industry under the Labor government was double that of the last 3 years in the Howard government. Let's pause on that. Double the Labor productivity in the construction industry under Labor compared to the coalition. And I know speakers on the other side will be tempted to compare the Labor productivity in the unionised sector versus the non-unionised parts of the construction sector. Any comparisons are facile because the unionised sector covers high-rise commercial construction sector, and they're trying to compare it to low-rise commercial construction in the outer suburbs, which is a completely different form of construction. The productivity story is very similar in the economy as a whole. I'm proud that economy-wide Labor productivity rose over 1% last year and 3.9% over the past 2 years. This is the highest in a decade, and our average productivity growth in the last 5 years has been twice that of the OECD average. So, on any available measure, Labor productivity under Labor's Fair Work model in the construction industry and in the broader economy is much stronger than when the coalition is in government. On industrial disputation, Deputy Speaker, the rate of industrial disputes in the construction industry is on average 1/5 of the rate we saw under the previous government. So we have higher productivity, we have less fatalities, and we've got industrial disputes running at 20% of what we saw in the coalition government, yet their solution to this supposed problem is to crack down on workers' rights. I would submit, Deputy Speaker, that this is incredibly unfair and just shows what the coalition is really about. The government remains wilfully ignorant of all the evidence that the current building industry regulation arrangements are working well. Labor has always supported a strong building industry regulator and a strong set of compliance arrangements for the building industry. Labor will not tolerate corruption, extortion or criminal behaviour in any industry, not just the construction industry. There is no evidence to suggest that the monitoring of compliance in relation to building laws has failed or is not occurring under the current provisions. The current Fair Work Building Inspectorate has considerable powers to obtain information, documentation and to have questions answered without compromising procedural and substantive fairness. The Inspectorate is undertaking more investigations, concluding investigations and getting matters to court faster and recovering more money for workers in the industry than the ABCC ever did. The Inspectorate has secured over $2 million in unpaid wages and entitlements for more than 1,500 workers, Deputy Speaker. These are the sort of the breaches that the ABCC was never focused on. Those opposite don't care about non-payment of employee entitlements, non-payment of employee superannuation, non-payment of workers' compensation premiums, and most importantly, in an industry where there is on average 1 fatality per week, they don't care about compliance with occupational health and safety standards. It is the government's responsibility to create a sound and workable industrial landscape in this country, Deputy Speaker. To achieve this, you have to have employers, workers and their representatives working together in a spirit of cooperation. Labor got this right under the Fair Work Act. Workers in this country have safeguards to protect their rights. Employers have safeguards to protect their interests, and representatives are acknowledged as having a legitimate role in Australia's industrial relations system. If I could go to examining the extreme nature of the ABCC's powers. Their powers are extreme, unnecessary and compromise civil liberties. They include unfettered coercive powers, secretive interviews and imprisonment for those who do not cooperate. People interviewed have no right to silence and are denied the right to be represented by a lawyer of their choice. This bill abrogates the privilege against self-incrimination, something that has until now been enshrined in the common law. In terms of the level of judicial oversight into investigatory powers, ASIO's investigatory powers into terrorist activities are subject to more checks and balances than the ABCC ever was. That is, if this legislation passes, Deputy Speaker, alleged terrorists will be entitled to a higher level of judicial protection than unionists. Let me pause on that for just one sec. If this bill goes through Parliament, terrorists and alleged terrorists will have more rights under our laws than unionists. That is just a disgraceful term, that's a disgraceful condition, and it just demonstrates yet again that this bill is not about promoting productivity, improving competitiveness, reducing disputation, increasing safety. It's about taking rights away from workers and saying to workers, you should have less rights than people alleged to be terrorists. Prime Minister Abbott refers to his workplace policies as returning the industrial relations pendulum back to the sensible centre. Interestingly, there is very little emphasis in this bill to tackle what I believe are some of the most serious issues in the industry, including non-payment of employee entitlements, non-payment of employee superannuation, non-payment of workers' compensation premiums, the use of Phoenix companies to avoid these obligations or avoid paying tax, and compliance with occupational health and safety standards in an industry with, on average, 1 fatality per week. These are the real issues confronting the construction industry. I've seen workers affected by companies shutting up shop one day, refusing to pay entitlements, then starting the next day with a slightly different name. It's even affected members of my family where all they've done is gone to work and work hard, and at the end of the day they've lost their pay and entitlements because of shonky contractors. This bill does nothing to protect those workers. All it does is attack them, Deputy Speaker. There are other areas of concern with this bill, for example, taking protected industrial action over issues of safety. An employee, when taking industrial action over safety issues, is required to prove their concerns about workplace health and safety only in relation to their personal safety. It is unclear whether this means that workers can take actions only when their own personal safety is jeopardised and are restricted from taking action over the safety of their colleagues. So let's pause on that for a second. If I'm working next door to another construction worker and I see his safety imperilled, it is unclear whether under this bill I can take action to protect that worker. I would submit, Deputy Speaker, that that is the most unfair set of conditions. Reversing the onus of proof is also a part of this bill, a part of the bill the previous Speaker was proud of. That is just a disgraceful state of affairs that the complainant bears the burden of proof. This undermines the tradition of innocent until proven guilty, which has been the bedrock of Western legal traditions. That, combined with the loss of the right of silence, means that this bill is taking us very far away from those traditions. I would submit that this is nowhere near the sensible centre the member for Warringah long promised us, because the truth is that the ABCC is not a watchdog, it is an attack dog. It is an attack dog aimed at attacking workers' rights. It's been condemned by the International Labour Organisation, and it is crucial that we oppose this bill because it attacks workers' rights, it attacks the rights of workers to organise, it will not improve safety, it will not improve productivity, it will not mean a single worker in this country will have a better chance of going home safer. The facts are that productivity in the construction industry is much higher now than when the Coalition was in government, when the ABCC was operating. Industrial disputation is 1/5 of where it was when the Coalition was in government. The industry is growing, it's strong, it was safe in Labor's hands, it's been jeopardised by the Coalition because all they care about is attacking workers' rights. Thank you, Deputy Speaker.